Welcome to the InfoSec Insider podcast, brought to you by URM, the UK's leading information and cybersecurity specialists.
Hi, my name's Annie and I'm here today with Stuart Skelly, who's one of our senior data protection consultants here at URM. Welcome to another episode of InfoSec Insider Talk DP. So today, Stuart and I are going to be discussing the most recent development in the ongoing case between the ICO and a company called Clearview AI. And the whole case has had a lot of coverage over the number of years that it's now spanned. So, Stuart, can you just tell us what the latest big news is in this Clearview AI case?
Yes, Annie. Well, on the 8th of October, the UK's data protection regulator for the ICO published on its website a press release announcing that the highly controversial 2023 decision of the first tier tribunal, as it's called, or the FTT, in this case of the US data scraping company Clearview AI Incorporated, had finally been overturned by a data protection appeals body known as the Upper Tribunal, or UT. It is quite a long ruling from the appeals panel, but suffice to say that the UT upheld the ICO's arguments in two enormously influential and potentially far-reaching, literally, respects. First, the UT, the Upper Tribunal, confirmed that what Clearview do, that's hoovering up millions upon millions of photographs of people's faces from the public-facing web without their consent, and acting on behalf of their law enforcement clients, all now located outside of Europe, though this wasn't always the case, such as the FBI and various police forces in North and South America, and then using facial recognition software to compare those images to faces caught on CCTV surveillance footage or these doorbell security cameras that you now see everywhere around the world, to assist their law enforcement agency customers in their work preventing or detecting crime. That all counts as monitoring for the purposes of the territorial scope of the UK GDPR in its Article 3. And because that monitoring looks at the behaviour of UK people as that behaviour occurs within the UK, then the relevant part of Article 3, that's 3.2b, is engaged. And the GDPR applies to that form of processing of UK people's data wherever it takes place in the world. And this is crucial, regardless of whether the entity, Clearview in this case, processing the data, the people's faces, has a physical establishment in the UK, which could be an office or a factory or a sales or distribution hub, but it could even be a single human worker. So this part of the UK GDPR is an important plank of the regulation's so-called extraterritorial effect. The idea and intention, I hesitate to call it a fact, for reasons I'll get onto shortly in this podcast, this extraterritorial effect, the idea that organizations monitoring personal information about the behavior of individuals in the UK should be caught by the GDPR and have to adhere to its principles and provisions protecting the privacy of people in the UK, even if those organizations are wholly based outside of it.
Thanks, Stuart. So you said the UK regulator won on two fundamental points. Could you just tell us what the other one was?
Secondly, and perhaps even more importantly, the UT agreed with the ICO that just because Clearview was acting on behalf of law enforcement authorities did not mean that the US company was able to avail itself of one of the exemptions from the material scope of the UK GDPR. That is the types of processing which the regulation doesn't cover, contained in its Article 2. That's the provision in Article 2.2b of the UK GDPR, which states that processing of personal data, like people's mugshots, by competent authorities for the purposes of prevention, investigation, detection, or prosecution of crimes are excluded from the material scope of the regulation, and therefore all processing by such competent authorities for those listed crime-fighting purposes is exempt. Now, in the UK, by the way, processing of personal information for the purposes of law enforcement is governed by separate legislation from the UK GDPR, namely Part 3 of the Data Protection Act 2018. In the original hearing of the Clearview case by the first-tier tribunal in 2023, the FTT controversially decided that despite not being a police force or similar organisation itself, Clearview was a competent authority, and therefore its activities with crime-fighting agencies benefited from the exemption. That was widely viewed at the time, including by myself a couple of years ago, as wrongly interpreted and a misapplication of the Article 2.2b exemption. However, that part of the FTT's ruling has now, to the great relief of the ICO, been reversed. Just working for a law enforcement authority does not make an organisation such as Clearview itself an anti-crime body. It's not a public legal authority, but rather remains a private company charging a fee to police forces and others and making money to do this sort of processing on their behalf. So the UT, the Upper Tribunal, has remitted the case back to the FTT for the ICO's original fine of £7.5 million imposed on Clearview to be reinstated by the lower tribunal. Really, as I said at the time, this was a case which the regulator couldn't afford to lose. And the sense of relief was palpable in the Information Commissioner's press release detailing the win. Clearview, for its part, has said that it will appeal against the UT's judgment to a senior civil court, the Court of Appeal of England and Wales. But it's hard to see what, in the UT's ruling, the US company can appeal successfully against. It all seems logical and watertight.
Thank you, Stuart. I think that interpretation of law enforcement makes a lot more sense to me as well.
Yes, it is more intuitive, isn't it?
The story doesn't quite end there, does it? There's a bit of a sting in the tail, and quite an important one at that.
Yes, Annie, because as with all court or tribunal rulings, that is not the end of the story. The UT's judgment and the ICO's upheld fine, to have meaning, have to be enforceable against the respondent company, Clearview. And this is where the ruling of the Upper Tribunal could actually turn out to be a hollow victory for the ICO and the UK GDPR generally. As the Commissioner's press release immediately after the judgment was issued suggests, it undoubtedly sets a valuable precedent on questions such as the definition of monitoring for the purpose of Article 3.2b, as I've said, and the interpretation of the law enforcement exemption in Article 2.2b. What the statement didn't make clear is the unpalatable fact that it is only of use against organisations with a physical presence or assets in the UK, such as a bank account or property such as office equipment, computers, etc., against which it can be enforced. Clearview, of course, has no such UK-based establishment or asset. This is a much underreported feature of the working or perhaps non-working of the GDPR, both versions, the UK GDPR and the original EU regulation. It's almost the GDPR's dirty little secret. Whereas over recent years, we have all become accustomed to eye-catching headlines about eye-wateringly large penalties imposed by European data protection authorities on the European headquarters of foreign-based global companies such as Meta, Amazon, and TikTok, and paid by them, with fines sometimes running into billions of euros. It's a little-known fact that there has never been a fine levied against a non-European organisation that has no establishment or assets in the UK or EU, which has been successfully enforced against such a company. Not one, in the getting on for 8 years that the GDPR has been in effect. And it's highly unlikely there will be a case of successful enforcement in these circumstances because the world currently lacks a method of enforcing administrative fines, which is what data protection fines from national regulators are, across borders. which kind of gives the lie to a significant part of the GDPR's much vaunted claim of having extraterritorial effect. What good is having an international law if you can't enforce it against those who break it, who are based solely in foreign countries? And when those countries include places like the US and China, where vast amounts of processing of personal data, including monitoring of the behaviour of people in the UK and EU, can the GDPR really be accurately described, as we've got used to doing, as the world's first global data protection law? What evidence is there that Clearview will not simply flout the UT's decision upholding the ICO's £7.5 million fine from 2022, just as the solely US-based company has ignored much larger fines for exactly the same infringements from no fewer than 4 EU data protection authorities in recent years: Italy, Greece, France, and the Netherlands, with fines ranging from €20 million to €30.5 million imposed, but not 1 cent collected by those European supervisory authorities. As a comparison, by the way, the ICO's £7.5 million fine on Clearview translates to around €8.5 million, not 30.5.
So does this mean the Upper Tribunal's very important correctives are simply going to be ignored by Clearview and other US businesses that are engaging in offshore monitoring of British people?
Well, Annie, that's a good question, and it's not clear. There's no clear view, you might say, where the ICO goes from here on this point. But in the absence of any special arrangement between the UK and the US for the enforcement of administrative fines, which seems especially unlikely at this point in history, where we have a president in the White House who seems to glory in his and his nation's current isolationism and views the EU and all things European as a particular bête noire. If that situation does not change radically, the UK privacy regulator does seem destined to follow the same rather dismal path of humiliation and irrelevance trodden by its European data protection authority counterparts before it.
That's not a very promising picture, but I think you can maybe leave us with the prospect of just a little hope on the horizon, potentially.
Yes, perhaps. Very recently, literally in the last couple of days, I read that Max Shrems, the Austrian gentleman who's probably the most famous data protection rights activist in the world, has been in touch with his local state prosecutor's office with a view to exploring whether criminal charges available under Austrian national data protection legislation can be brought against Clearview and its directors personally. Unlike for administrative fines, there are, of course, well-developed international systems in place for many years for enforcing criminal charges and fines across borders, such as extradition treaties and mutual recognition and enforcement of criminal penalties agreements. So such a move could prove more effective in bringing Clearview to justice eventually. But we'll have to see if the Austrian prosecuting authorities have the stomach for that fight.
So we might have a ray of light to end on there.
Yes, and we at URM will be watching out for any announcements from Austria and Mr. Shrems on this topic, of course. It's a very recent development, as I said. But I have a feeling we have far from heard the last of Clearview AI on this matter. Although with this recent ruling of the Upper Tribunal, the ICO might have felt that Clearview had lost the final decisive battle, I don't believe the war is over. Not by some way.
Amazing. Thank you so much, Stuart. If any of our listeners want to learn a little bit more about this topic, there's a blog on our website, urmconsulting.com, called ICO's Appeal in Clearview AI Case Upheld, and that's going to be linked in the description. Thank you so much for listening today, and we will see you next time. If you've enjoyed this podcast, we would really appreciate it if you could spare a moment to leave a rating or review at ratethispodcast.com/InfoSec Insider. To listen to more episodes, you can find us on Spotify, Apple Podcasts, YouTube, and Podbean.
Thank you for listening to URM's InfoSec Insider podcast. For more information, visit our website at urmconsulting.com.